The next item of business is consideration of business motion 18901 in the name of Jamie Hepburn on behalf of the Parliamentary Bureau, setting out a timetable for the Stage 3 consideration of the Victims, Witnesses and Justice Reform Scotland Bill. I ask any member who wishes to speak to the motion to press their request to speak button. And I call on Jamie Hepburn to move the motion.
Move, Presiding Officer.
Thank you, Minister. No member has asked to speak to the motion. Therefore, the question is that motion 18901 be agreed. Are we all agreed? Yes. The motion is therefore agreed. The next item of business is Stage 3 proceedings for the Victims, Witnesses and Justice Reform Scotland Bill. In dealing with the amendments, members should have the bill as amended at Stage 2, that is SP Bill 26A, the marshalled list, and the groupings of amendments. The division bell will sound and proceedings will be suspended for around 5 minutes for the first division of Stage 3. The period of voting for the first division will be 30 seconds, and thereafter I will allow a voting period of 1 minute for the first division after a debate. And members who wish to speak in the debate on any group of amendments should press their request to speak buttons or enter RTS in the chat as soon as possible after the group has been called. Members should now refer to the marshalled list of amendments. And we move to Group 1, Victims Charter. And I call Amendment 4 in the name of Jamie Green, grouped with Amendments 5, 9 and 28. Jamie Green to move Amendment 4 and speak to all amendments in the group.
Thank you, Presiding Officer. First of all, can I take this opportunity to thank very quickly at the opening of today's debate, particularly the Parliament's clerks who have assisted a number of particularly backbenchers and opposition members with the drafting of amendments where we didn't have the support of the government. Also to thank the Cabinet Secretary and her team, including her civil servants who have assisted on areas of mutual interest to draft amendments, but particularly, as I'm sure others will do, my own staff who have worked incredibly hard over the last few weeks and indeed months to assist with today's amendments. We come very neatly to the first group, which is the Victims Charter, which will be a duty placed on the Victims Commissioner, should such a Commissioner be created through the course of today. First of all, I would say that I do understand and accept that there is a plurality of views on the establishment of a Victims Commissioner. A number of victim support organisations are in favour of it, others are not, and there has been a mixed response to the Criminal Justice Committee's report on this legislation. So, notwithstanding that, should such a Commissioner be created as a result of voting today, I felt it imperative that the Commissioner had a very specific and clear task to do on day one of taking office, and that is the creation of the Victims Charter. I'll talk through the amendments briefly, Presiding Officer. Amendment 9 is the substantive amendment in this group. It inserts a new section into this bill which outlines a requirement for the new Victims and Witnesses Commissioner to prepare and publish a Victims Charter within 1 year of this section of the bill coming into force. In preparing the Charter, the Commissioner must consult a number of key people, including victims themselves, victim support organisations and criminal justice bodies and partners. The amendment, and this is the important part, is what will be in this Charter. Now, I unusually was quite specific in my Stage 2 amendment about what I thought this Charter should or should not contain in order for it to be a meaningful and helpful document and not simply repetition of other pieces of advice that are in the public domain. And unusually, the government accepted verbatim what I proposed, and that has also carried through to Stage 3. Particularly, the Charter will outline for victims who often have had very little or no experience of the criminal justice system an end-to-end description of the criminal justice system in Scotland itself, which does differ from other parts of the UK. It will also outline the interactions that a victim may have with the system at various points as that person goes through their journey of reporting a crime, being identified as a victim, through to the relevant court proceedings, sentencing and even through parole and thereafter. So what is that person's rights throughout their touch points in the system? It will also explain the communications by which a victim will receive throughout the course of his interactions. We do know that at various points victims are communicated with by various bodies and agencies to a meaningful degree or otherwise, as we will come on to in later groups. It will also outline, or it must outline, what victims' rights are throughout these interactions. Again, that's from feedback that I've had, that is not always obvious or indeed the case. It will further detail to victims what the mechanisms are available to them as to how they may uphold the rights that they hold. And, of course, it's open-ended, so the Commissioner may consult more widely and add other matters into it as it considers appropriate. The point being is that it should be promoted by stakeholders once it is completed. So there is an Amendment 4 and 5 which has a duty on the Commissioner to ensure that the Charter, when completed, is promoted by partners. And that could be, for example, it could be issued as a booklet or a pamphlet to people when they report a crime at police stations. It could be distributed by solicitors or lawyers, by charities in the third sector who support victims, the courts themselves, and even the NHS and other touchpoints where people may interact with the public service. And the purpose of that is to inform victims at the earliest possible stage as to their journey through the justice process. Yes, happily.
Liam Kerr.
I'm very grateful. I think the broad thrust of Jamie Green's amendments are reasonable, and I'm inclined to support them. Although I do make note that there's an awful lot in the Victims' Code that seems replicated in the Victims' Charter. But, Mr Green, given the requirements for the annual review and the concerns that we've heard from Scottish Women's Aid about the potential to take Commissioner resources away from other priorities, and the promotion that he's just talked about, how much time and money does Jamie Green think will be spent on producing and reviewing this Charter every year, as opposed to the other work the Commissioner is doing?
Jamie Green.
Can I thank Mr Kerr for his comments and as always, constructive and helpful feedback throughout our negotiations in this bill. I think that the first draft and iteration of this will require some work and time, and inevitably that will come at a cost. That will be enveloped in the costs associated with the running of the Office of the Commissioner. I appreciate there are a range of views on that. The annual review is indeed such a review. It's not a complete reproduction of the Charter. I don't expect it to be completely rewritten year on year on year. However, what may happen throughout the course of a political year, if you like, is there may be legislative changes or other changes to guidance, for example, that have been issued as a result of secondary legislation, or other changes that the government itself we expect to make. So, for example, I know the government have just performed a consultation on parole reform. So, for example, that may result in changes to guidance or SSIs which come through Parliament. They must be reflected in perhaps in future iterations of the Code. Equally, the third sector itself is evolving, and therefore the nature of advice that is available and given to people may change over the course of time. So I suspect that as the years go on, it will require updating rather than complete renewal, and therefore the workload is less as time goes on. But I think, I think to get to the crux of Mr Kerr's point is what I want, and this is something that has been expressed, is we don't want a commissioner for commissioner's sake. We've had long debates in this Parliament about that. We want a commissioner that has something meaningful, that will actually offer victims something tangible. And I think this is something tangible. This is something that will be in friendly language that anybody could pick up and understand what they're about to go through in terms of their journey of the process. And I am genuinely pleased that Victim Support Scotland support the Charter and the creation of it. In fact, they said in their briefing to MSPs that they support the preparation and publication of a Charter as part of the Commissioner. We note that it's complementary to the existence of the existing Victims' Code, and we welcome the increased awareness that these rights, when coupled with the powers of the Commissioner, will offer victims. The Victims' Code itself, which he rightly points out, is a good document and is one that already exists. But I have to say, none of the victims that I've met over the course of the last 4 years have ever heard of it or ever read it. So it's clearly not been promoted, and it clearly has limited scope in terms of the interactions that people may have with the justice system. So I hope it goes further than the code itself. And it's not dissimilar, actually, to a similar charter which exists in England and Wales, which victims are presented with. So overall, I think the whole package should create a meaningful piece of work for that Commissioner to do on day one of his job or her job, should that person be created as a result of today's business. I'll leave it there, Presiding Officer. Thank you.
Thank you. And I call the Cabinet Secretary.
Presiding Officer, I'm conscious that we've got over 160 amendments to get through today, so I will leave my thanks to everyone who's contributed to this bill to later in proceedings. But in terms of Group 1, I am very pleased to have been able to work with Jamie Green on these amendments. As he has outlined, they will establish a Victims' Charter, which the Victims and Witness Commissioner will prepare, publish, promote and lay before the Scottish Parliament. It is right that this duty will be on the Victims and Witness Commissioner, which this bill, if passed tomorrow, will establish as the person who has the role of raising awareness of and promoting the interest of victims and witnesses. And I am pleased to support the amendments in this group. Thank you.
Thank you. And I call Jamie Green to wind up and press or withdraw Amendment 4.
No further comments to add, and happy to move the amendment.
Thank you. The question is that Amendment 4 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 5 in the name of Jamie Green, already debated with Amendment 4. Jamie Green, to move or not move?
Moved.
The question is that Amendment 5 be agreed to. Are we all agreed? Yes. We are agreed. We move to Group 2, Victims and Witnesses Commissioner, Functions and Definition of Victim. I call Amendment 59 in the name of the Cabinet Secretary, grouped with Amendments 8, 60 and 61. The Cabinet Secretary to move Amendment 59 and speak to all amendments in the group.
Thank you very much, Presiding Officer. I will deal firstly with Amendments 59, 60 and 61 in this group, which provide a revised and broader definition of victim for the purposes of the work of the Victims and Witness Commissioner. Amendment 59 adds a specific reference to the role of the Commissioner in relation to the Victim Notification Scheme in Section 2 of the Bill. The Bill on Introduction defined victim broadly to avoid the risk of anyone being unintentionally excluded from interacting with the Victims and Witness Commissioner, either as individuals or via engagement with victim support organisations. We are revisiting this to ensure an appropriate approach to what is meant by victim following discussions with Victims Group. Liam Kerr did raise issues with the definition at Stage 2, and while these changes are not directly related, I know we are all looking to ensure that the definition is appropriate. Amendments 60 and 61 expands the definition of victim to expressly include those persons who have firstly suffered harm as a direct result of having seen, heard or otherwise directly experienced the effects of such conduct or harmful behaviour by a child. Secondly, those eligible to receive information under the Victim Notification Scheme. Thirdly, relatives who are prescribed for the purpose of receiving information through the Victims Code and Standards of Service under the Victims and Witness Scotland Act 2014. Amendment 8 was developed in relation to concerns raised by some of the criminal justice bodies, as with the separate amendments to change the term Criminal Justice Agency to Criminal Justice Body, which I will speak to in Group 4. Amendment 8 is designed to meet the concerns expressed about perceptions of the independence of decision-making within the justice system. Amendment 8 therefore puts on the face of the bill that the Victims and Witness Commissioner may not exercise their functions in a way which adversely impacts the decision-making of criminal justice bodies and therefore expressly protects their independence. And I move Amendment 59.
Do you wish to add any winding-up comments, Cabinet Secretary?
No, thank you, Presiding Officer.
Thank you. The question is that Amendment 59 be agreed to. Are we all agreed? Yes. The amendment is agreed. We move to Group 3, Minor and Technical. I call Amendment 6 in the name of the Cabinet Secretary, grouped with amendments as shown in the groupings. Cabinet Secretary to move Amendment 6 and speak to all amendments in the group.
Presiding Officer, the amendments in this group change the term Criminal Justice Agency or agencies to Criminal Justice Body or bodies in Part 1 and Schedule 1 of the Bill. which relate to the Victims and Witness Commissioner. These criminal justice bodies, as they are proposed to be known in light of these amendments, are listed in the bill as the Lord Advocate, Scottish Ministers, Police Scotland, Scottish Courts and Tribunal Service and Parole Board for Scotland. These amendments were developed in relation to stakeholder feedback and in particular a concern raised by the Parole Board for Scotland about how the term agency could be perceived as they operate independently of Scottish ministers. We consider that the description criminal justice body addresses that concern, whilst it does not have any impact on the legal standing of any of the criminal justice bodies included within the definition. It is considered a more neutral term than criminal justice agency. This avoids any suggestion that those independent bodies are in any way subordinate to Scottish ministers or the Victims and Witness Commissioner, or a suggestion that the Commissioner or Scottish ministers are able to direct them. I move Amendment 6 and other amendments in this group in my name.
Thank you, Cabinet Secretary. I'll just confirm if you wish to add any further comments.
Nothing to add.
Thank you. The question is that Amendment 6 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 7 in the name of the Cabinet Secretary, already debated with Amendment 6. Cabinet Secretary to move formally.
Moved.
The question is that Amendment 7 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 8 in the name of the Cabinet Secretary, already debated with Amendment 59. Cabinet Secretary to move formally.
Moved.
Thank you. The question is that Amendment 8 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 9 in the name of Jamie Green, already debated with Amendment 4. Jamie Green to move or not move?
Moved.
Thank you. The question is that Amendment 9 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendments 10, 11, 12, 13, 14, 15 and 16, all in the name of the Cabinet Secretary and all previously debated. I invite the Cabinet Secretary to move Amendments 10 to 16 en bloc.
Moved en bloc.
Thank you. Does any member object to a single question being put on Amendments 10 to 16? No member objects. Therefore, the question is that Amendments 10 to 16 are agreed to. Are we all agreed? We are agreed. We move to Group 4, Victims and Witnesses Commissioner, Power to Gather Information. And I call Amendment 17 in the name of the Cabinet Secretary, grouped with Amendments 19, 21, 96, 97, 24, 98, 99 and 100. And I call on the Cabinet Secretary to move Amendment 17 and speak to all amendments in the group.
Presiding Officer, I will begin with Amendments 17 and 19 in my name. There are provisions in the bill relating to the information gathering powers of the Victims and Witness Commissioner, which are subject to certain exemptions. Amendments 17 and 19 clarify that a criminal justice body or the Lord Advocate can refuse to provide information in certain circumstances rather than being obliged to provide this information, which is the current wording. This ensures consistency of language and makes absolutely clear that refusals are not overridden by the requirement to provide information to the Commissioner. Amendment 24, which is linked to Amendments 17 and 19, makes clear that the right of the Commissioner to report to the Court of Session or publicise the criminal justice body's failure to provide information does not apply where the criminal justice body is relying on the exceptions in sections 14(3) or 4. That is, where they could refuse to provide information to a court, or in the case of the Lord Advocate, where that might prejudice criminal proceedings or be contrary to the public interest. Amendment 21 provides the Commissioner with an alternative route to the Court of Session where a criminal justice body has refused to provide information based on the exception in section 14(3) and the Commissioner wishes to challenge that refusal. This ensures that the Commissioner's ability to take enforcement action towards criminal justice bodies where appropriate is not undermined, and I would urge Parliament to support my amendments in this group. Presiding Officer, I cannot support any of the amendments in Sharon Dowie's name. Ms Dowie's Amendment 96 and 97 would place a duty on local authorities and providers of social housing to provide information requested by the Victims and Witness Commissioner for the purpose of determining the support that the person is providing to victims and witnesses. It would also bring these organisations into the scope of enforcement provided for in the bill, which currently applies to criminal justice bodies only, as is appropriate for the Victims and Witness Commissioner. Ms Dowie's amendments appear unnecessary and disproportionate, and I can reassure the member, however, that Section 6(2) of the bill provides the Victims and Witness Commissioner with the power to engage with such bodies as they consider appropriate, and Section 7 allows further flexibility in how the Commissioner discharges their duties. In addition, under Sections 10 and 12 of the bill, where the Commissioner is conducting an investigation, the Commissioner can require any persons to provide evidence or documents. Therefore, as the Commissioner already has the power to engage these bodies as part of their functions, and I do not consider it appropriate for such bodies to be subject to enforcement and the requirement to provide information in the same way as criminal justice bodies, given the nature of the work of the Commissioner, I urge members not to press these amendments. Ms Dowie's amendments 98, 99 and 100 also seek to bring local authorities and providers of social housing into the scope of enforcement provided for in the bill. This does not seem appropriate for the reasons I have already set out. For such changes as Ms Dowie is proposing in the group to be introduced at this stage, I would also expect for there to have been considerable engagement with councils and social housing organisations to seek their views on the impact of them, and I suspect that this has not been possible. Therefore, I urge the member not to press the amendments in this group and for Parliament to oppose them if they are pressed, and I move Amendment 17.
Thank you. And I call Sharon Dowie to speak to Amendment 96 and other amendments in the group.
Thank you, Presiding Officer. My Amendment 96 would give the Victims Commissioner the power to request information from local authorities and social housing providers for the purpose of determining the support that they are providing to victims and witnesses. This was suggested to me by Victims Support Scotland, who back it, and all MSPs will be aware from our casework that local authorities and social housing providers play a key role in supporting victims. This power to request information from them will help assist the Commissioner to assess the support these bodies are providing to victims and their compliance with the Victims Code. Amendments 97, 98, 99 and 100 are all technical amendments in consequence of Amendment 96. I do have concerns about the potential for a Victims Commissioner to drain resources from victim support services, but I recognise that if this bill passes, we will have one. So we must give them the tools they need to effect change for victims. There is no point in having a Commissioner if they cannot hold all relevant agencies to account. If any MSP here has ever been contacted by a constituent who has been failed by a local authority or social housing provider, they should back my amendment today on their behalf. I move my amendments. Thank you.
Thank you. And I call the Cabinet Secretary to wind up.
Thank you, Presiding Officer. I would just like to stress to Chamber that these amendments are new to Stage 3, and unfortunately I didn't hear Ms Dowie make any reference to consultation either with social housing providers or local authorities. And as I said in my opening statement, in terms of exercising their Victims and Witness Commissioner, in a moment, in terms of the Victims and Witness Commissioner exercising their duties under the Act, they can, of course, engage with any relevant party.
Liam Kerr.
Just on a point that the Cabinet Secretary said there about amendments being new to Stage 3, can we take it then that any amendments that are completely newly introduced at Stage 3 will not find favour with her?
Cabinet Secretary.
Well, Presiding Officer, I think that depends on the consultation and engagement that has taken place. And I repeat the remarks with respect to Ms Dowie that I have not heard her make any reference to the engagement that she has made with those impacted by this amendment, namely housing providers and local authorities.
Thank you. The question is that Amendment 17 be agreed to. Are we all agreed? We are agreed. I call amendments 18, 19, 20 and 21, all in the name of the Cabinet Secretary and all previously debated. I invite the Cabinet Secretary to move amendments 18 to 21 en bloc.
Moved en bloc.
Does any member object to a single question being put on amendments 18 to 21? Yes. Okay. That being the case, we will put questions on each amendment individually. The question is that Amendment 18 be agreed to. Are we all agreed? Yes. We are agreed. The question is that Amendment 19 be agreed to. Are we all agreed? Yes. The question is that Amendment 20 be agreed to. Are we all agreed? Yes. And the question is that Amendment 21 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division. And as this is the first division off the stage, I will suspend for around 5 minutes to allow members to access the digital voting system.